70. What is the matter? Oh, it is kept when? 25th July. It can come to, it can go to 11th July. Whatever you want to do. That matter is kept, first 4 matters.
List 1, serial number 130.
No, that matter is kept specially 230. That 4 matters.
Sorry, madam. List 2, serial number 1.
So that is now the manner. I'm sorry, that manner in which it was disposed of slipped from my mind.
I'm sorry.
Therefore, it is re-notified.
Yes.
Now we got it. This is to be created as show cause notice.
Yes. Yes.
But to be heard.
Yes.
To be supplied report.
Please.
And the decision is to be taken.
Correct. That's all. In fact, I was grateful.
That's
It was a limited, short lordships. It was a very short point which lordships disposed of, saying that this impugned order should be considered as a show cause notice, and then we must be given an opportunity to reply.
in today's date.
Please.
Serial number 4. Sridhar Hegde.
In this case, my lord, annexure Q.
They've given a copy of it. Technically, a personal hearing is not being given to them.
What is
The closure order. The Pollution Control Board has passed a closure order, which is at page 111, annexure Q. So that's, I have verified whether we have not given them a personal hearing. That's on a limited point. This may be treated as show cause notice. This is only my request and suggestion. It may go back to them so that orders may be passed in accordance with law.
Lord, on 21st, your lordship passed order on the basis of show cause notice which is issued. Your lordship, they have submitted before this honorable court saying that this is, my lord, the only notice that they will consider our statement of objection. But backdated, this order came to be passed. Therefore, my lord, if they are treating as show cause notice and providing opportunity to us to, my lord, hearing opportunity, then, my lord, it can be treated as show cause notice and disposal. And till disposal of that, my lord, I may permit it to continue. Q and R.
Annexure Q and R. What has happened, my lord, we had given them an NPD and a personal hearing last year. Now, after that, we have again issued an NPD. We should follow the procedure, my lord, of giving them a personal hearing, which we did not do.
What is challenged in this petition filed under Article 226 of the Constitution is order dated 19th April 2025, passed by the competent authority of the respondent number 1 Karnataka State Pollution Control Board, whereby the
annexure R,
Q and R.
Q and R.
We'll pass the orders. Next. We don't tolerate any interference in the order. We know everything. I'm in complete command of the facts of every matter.
I'm sorry.
Yes.
We are sorry.
We'll pass the order. As
Please,
suggested.
sorry, my lord, because
Next.
Bill number 5, Mr. Prakash MH.
I'm complete command of the facts of every matter.
I'm agree with
Take
that.
it. So don't
To
please interfere.
assist, my lord, that's all. Simply, we are assisting your lordship. Therefore, my lord,
We don't want any assistance in our order. It is our order without any assistance. You argue and complete, take your seat. No interference when dictation is order is going on. Every time I have to tell and get angry for that simple purpose, which you don't understand. And waste the time of the court and the energy of the court also.
we are extremely sorry if it is.
Yes, next.
Number 5,
For respondents.
Yes, what is it?
Matter. So matter is settled, my
have
lord. Parties
settled
are
the
present.
matter. In
So
fact,
mat-
because the appellant was not present, my lord, in the court, when the case was called out, I made a submission for passing over the, Lord, the respondent number 6 has petitioned before the lower single judge challenging a revisitation of the award, which was done at the instance of the appellant. Lord, subsequent to passing of the order by the lower single judge, there is a truce between the appellant and the respondent number 6, whereunder they have shared insofar as the sites which are benefited by virtue of the acquisition in lieu of compensation. Lord, accordingly, the compromise petition is filed and parties are before this honorable court. In fact, the vide is also not having any objections so far as the compromise that it is entered between the appellant as well as the respondent number 6. my lord, sir.
So where is the
side.
compromise?
Please.
Where is the compromise?
It is, we have filed it. We have
It's
filed it.
already on board, my lord. It's already on board, my lord.
Already on record.
Yes.
Please. Lord, we had filed it on.
At page 10 and 11, my lord, may send it on to appellant is entitled for 3 sites and the contesting respondent herein is entitled for 2 sites. And one request will is, one memo is,
You record the presence of parties and
a party
yes. What is your name?
He's there. He's there.
Rudresh.
Yes.
So compromised?
Yes.
What is the settlement? What is the settlement?
He can't understand the English, my lord, sir.
What is the settlement? Tell us the settlement, they will not record it. Explain them, explain them and come tomorrow.
No. He can't understand English.
That is the whole thing. If they understand what is the
No,
settlement. to be
He
recorded.
can explain it in the local language, my lord.
He doesn't understand English and you are drafting in English. So how is the free consent? Yes, what is the settlement?
ಸರ್ ನಮಗೆ 5 ಸೈಟ್ ಅಲ್ಲಿ ನಮ್ಗೆ 3 ಸೈಟ್ ಇವ್ರಿಗೆ 2
Now you come with, you translate the settlement in vernacular and come tomorrow. Other will not record the settlement. unless we are satisfied that they are satisfied. Next. Come tomorrow with translated copy.
please,
of
please,
the
please.
And give them the translated.
Definitely,
copy,
definitely, my lords.
So
Definitely.
that they can
Yes.
understand what is it
Yes,
written
yes.
in English language. Correct? Tomorrow at 11 in the separate board.
Seal number 6.
My lords, I'm appearing for the petitioners. I'm being led by Senior Counsel Jana Kothari. She's on her legs in another court hall.
Then beyond vacation.
Can I?
Which is that seal number?
This is 6, my lords. So,
Six
my
in the
lords,
separate
just to,
board.
Last date also, I'm sorry.
What is it about?
Lake matter, my lord.
Lake matter reserved for.
Reserved, there's nothing
It
remains.
is reserved.
Reserved.
please, my lord. My lords, I'm just seeking a short accommodation, my lords.
No, it was reserved, then released because it was heard substantially and fully by this bench. Therefore, it was placed before this bench only to repeat the order of reserve.
Debut registry also, your lordship were pleased to post it today only to reserve the matter.
Reserved,
That's all, my
so reserved. Give the appearance and reserved, standard reserved, yes.
Lords, may I
But
seek
can I
one,
make one
may I seek one
submission?
indulgence? Once I have filed IA-2 of 25 for impleading, since your lordship is reserving it. It's just a small matter about a neighborhood NGO that wanted to assist in cleaning the outside of the lake. Your lordship permits me to file some written submissions on just the, because now your lordships have reserved it.
You are impleaded?
I'm not yet impleaded, I just filed the
We'll
application.
see.
Lord, can I make one submission? Lord? I'm also
No,
an
sir.
application for,
No submission.
Lord, one request, Lord. I filed an application for impleading. Lord, insofar as my Lord, property is concerned, no matter what had gone up to the Honorable Supreme Court, where my title has been confirmed, despite which, my Lord, they've thought to include my property, my Lord, in this litigation. In fact, earlier a PIL was filed. That PIL was dismissed. I've been declared as the owner of the property, my Lord, confirmed by the Honorable Supreme Court.
My lord, the matter is pending 10 years. If the matter is kept pending, more IAS and IAS will keep coming. Correct. Please,
Deeply obliged.
please.
Very well. Please, Lord. Yes, Lord. Yes, Lord, I shall. Yes, Lord, I shall, Lord. I shall.
When will you?
Very well, Lord. By second, I shall give. Very well. Please. Because in fact, earlier PIL that was filed, Lord, that was also dismissed by the Honorable Court, saying because the government has, Lord, after the Honorable Supreme Court dismissed the SAP filed by the state government, the government filed a writ petition challenging the order of the land tribunal. That writ petition is pending before the single judge. Therefore, PIL that was filed insofar as, Lord, my property is concerned, the PIL was dismissed, saying that, Lord, the matter will be agitated before single judge. That writ petition is filed by the state government.
The lordships are not deciding individual rights in this case, my lord.
No, but my right is already concluded. I cannot be made to undergo another round of litigation. If Lords,
Have the served copy
My
of
lord,
that application?
So,
I've received from them,
No,
but
no.
not, yeah, not.
They're all impleading application.
He's also an impleader.
Main matter is yours.
Correct, sir, but he's also impleader.
the Lords have to give me just 2 minutes, but I'll just show those orders, Lord.
that is not the
Because
subject matter, my lord.
Difficulty is, Lord. Please, Lord.
Nothing, my lord. There's no relevance to this case at all.
Lord, what has happened is, Lord, my instructions are, Lord, there was a direction by this Honorable Court to the BBMP to conduct, Lord, spot inspection, give a report, Lord. That report, Lord, is sought to be given before this Honorable Court. Of course, a copy is not furnished to us. But, Lord, my property is also, Lord, allegedly shown, Lord, in that report. My difficulty is, Lord, after having fought for more than 30 odd years, Lord, against the government and having succeeded, and the Honorable Supreme Court having confirmed, Lord, the judgment decree of the trial court. But now, Lord, if I'm made to suffer another round of litigation, Lord, what the government has done is not only, Lord, in this proceedings, Lord, they have initiated proceedings, Lord, before the Lord land grabbing court, despite there being a decree, Lord, in my favor. Then, Lord, there are proceedings initiated, Lord, before, Lord, this even the NGT. Therefore, Lord, everywhere, Lord, I'm being targeted, despite, Lord, there being a clear decree that it is not a lake bed, it is not a Hiduvadi land.
Nothing to do with this case, my lord.
Your lordship may make,
Lord, not at least clarify not that wherever there's a decree or not wherever there's an order not in favor of the parties, that will not be affected not by the order that Lords may pass. Very well. Very well. I'll file my written submissions. I shall.
Your Lordship may make one sub. See, NEERI has already given a report, Your Lordship. So then based on that, the government also conduct survey. All these things, once that reaches the finality only about the implementing application, the court can consider it. Not because by deviating the main matter. So now your issue is regarding the maintenance of like, that arguments have been heard now. So as far as other implementing applications can be considered at a later point of time. That's my responsibility.
Please.
You want to
This is let everybody give whatever by second is concerned, Manoj.
written submissions have been given already. It's given. It's already been given by all.
From petitioners and we have already
We will give
compiled
letters.
all
We are
the
given.
prayers from everybody.
Yes, sir.
Please.
Seal number 7.
This is similar matter, your lordship has reserved it.
Really, ಒಂದು ನಿಮಿಷ ಇರಿ. quickly move ಮಾಡಿದ್ರಿ.
The lordship has reserved earlier, subsequently released, as this court, this bench has heard. This bench has heard it was released.
No, this is the matter, my lord, pertaining to the flexes, my lord. Only prayer is, my lord, that the advertisement policy is there. Advertisement policy, my lord, is,
No, it can be final.
Lordship
Because Lordship, this bench can decide that matter finally. And in fact, in spite of that, several holdings have come up yesterday. Few holdings have fallen off.
all
Whatever
necessary
holdings,
steps have been taken, my lord.
Here's my letter friend photo. This is all happening. Unless that
All
they are saying
necessary,
about the policy.
each police station has been
How to
done.
implement is important. Till then, your Lordship, this court of maintain monitoring, so they are under control.
Lordship had reserved only the first matter, my lord, 57990. That is-
First matter is. First matter is.
I'm the petitioner. For the petitioner.
It is pertaining to the state, my lord. He has made an application for the state. Your lordship had delinked it, my lord, on the last occasion.
That's all.
Now
So
again,
moto and other things.
it could be delinked, my lord. It is not pertaining to Bangalore.
Only two matters your Lordship heard it and reserved for a judgment. Then because of the other bench has not considered, it was released on 16th January, it was reserved. Then subsequently it was released from parted.
22/11/2019, my lord. What happened, my lord? Actually, all this has happened in 5703. There was a direction on 1/8/2018 to remove all the wordings. Subsequently, on 22/11/2019, this honorable court said we will look into the aspect of this indicated on 22/11/2019. Actually, the entire order started passing on this petition only. 1/8/2018, the court called, immediately it has to be removed. And subsequently it was scrubbed. Much.
May I be permitted to make one submission, my lord? I heard that your lordships are inclined to reserve the matter. I have one request, my lord. In this main matter, my lord, 5957990 of 17, we have filed an application, my lord. During the pendency of the proceedings, my lord, the draft bylaws were notified. And since your lordships are seized of the matter, my lord, they have not been given effect to. My lord, their main grievance, my lord, is that the provisions of the 81 Act must be given effect to. And there was no proper regulation of what is to be done. Now, my lord, by virtue of the interim orders of the honorable court, all advertisements, my lord, were stopped. We are losing, my lord, huge revenue. So therefore, my lord, in the light of all the objections that have been received, we have formulated bylaws. And it's the legislative act, my lord. May I request your lordships to make it clear that the fact that your lordships have reserved orders on this will not come in the way of our notifying the bylaw. Because ultimately, if the bylaw is not in accordance with law, my lord, they'll have to challenge it. But making of the bylaw, my lord, would that be stayed is a subject, my lord, your lordships may please consider.
That bylaw has to be in conformity with the Karnataka Open Places Prevention and Replacement of 1981. So that is the main issue with us. All the things.
No, we placed the bylaw before the honorable court, my lord.
It is there already.
Yes. So what I'm submitting, my lord, is that by your lordship's order, my lord,
modified it.
a legislative action, my lord, this making of a bylaw, my lord.
There are two things.
Making of the bylaw, my lord, will not adversely affect them or anybody, my lord. Ultimately, my lord, what is happening today, if the bylaws come into force, the BBMP will be able to recover sizable sums by way of revenue. That has not been possible now, my lord. We are hard pressed for money, my lord. And if those bylaws are contrary to law, nobody has challenged, my lord. Till now, it has not come into force. So the question of challenge doesn't, when it comes into force, my lord, the challenge is open to them. That's my humble request, my lord. Let that not be stayed, my lord. The making of a bylaw cannot be stayed, is my respectful submission. The whole grievance, my lord, is 81 Act. 81 Act, my lord, has to be complied. If this bylaw is shown to be contrary to 81 Act, my lord, it will have to go. That's all my submission.
It can be concerned immediately after vacation.
May I submit, my lord? There are two difference in advertisement, my lord. One is advertisement in accordance with law. There are two things, my lord. One, the advertisement is in the advertisement, birthday wishes, everything is quite contrary to law. They are not taking any permission. They say, yes, my lord.
Make it that all the matters are reserved, my lord. Great.
Seven point one delete, my lord.
This is number 8, Chandrasekhar L.
I appear for the petitioner. Lordship, may kindly see the last order dated 9/4/25. My lord said, taken a, may I just take my lord through the order? In the compliance affidavit dated 7/3/22, filed by the Tahsildar Bangalore and the civil contempt proceedings following governments are found, I most respectfully submit in compliance with the order passed by this honorable court. No, my lord, this is that Podi and Durast. They filed an affidavit before the court, got a contempt clause saying I've complied with the order. Then they come to your lordships now and say, I want to appoint the Taluk surveyor again. Despite your lordship's order, my lord, in the writ appeal, granting them 4 weeks' time to comply with the order. Please see para 3, my lord. Now, nothing has happened, Lord. They are refusing to comply with this order, with your lordship's order. They have not challenged that order. There are 4 rounds of litigation now which have gone on. They are one way or the other, my lord, ensuring that the work is not completed. There is already a plan on record.
Please. Please, President.
Yes.
My lord, what has happened, my lord? If my lord permits. My lord, this is land bearing survey number 65, my lord. Apart from the petitioner, there are other owners in the land, my lord, occupant. Please, we have issued notice, my lord, for the demarcation of boundaries and fixing. Please, please. Please. Please, please, please. My lord. No, my lord, no, my lord. My lord, we have issued notice, my lord, for fixing of boundaries. The Podi Durasta requires, my lord,
This is, I think, my
fixing
lord,
of the boundaries.
I'm sorry.
My lord, there are 5 other occupants in the entire land.
My lord, please see your lordship's order, my lord. At the contempt order itself says so. My lord, original order is 4 weeks' time. That too in the contempt proceeding. Your lordship granted it in the contempt proceeding, my lord. Please see the order annexure A, page number 24.
We'll do it.
The order was passed in very strong language on 9/4/25.
Please.
For what purpose you are here to say that we are going to do it? Why did you not work it?
Lord, the Podi and Durast requires fixing of boundaries, my lord.
Podi and Durast supposed to be completed in August.
4 weeks, my lord, from
4 weeks.
24,
Please.
December 24.
This was the order under
Please.
in the earlier proceedings. Your stand was that the Podi and Durast was already completed. Despite their filing another petition and obtain this order. Now you are not complying with this direction, nor you are recognizing the earlier Podi and Durast.
Please see page 77, Lord. The sketch is there. After carrying out this entire exercise, page 77, that is the sketch. The Podi and Durast has been completed. They refuse to recognize it because, my lord, some individuals don't want to do it. 77. My lord, then they initiated one more proceeding against us to try and get an order against us. My lord, every single time, my lord, first they say grant is not valid. It is upheld. Then this honorable court says grant is valid. Then they initiate one more proceeding under 136(2) to try and somehow ensure that I cannot not utilize this land. And then finally, your lordship's not, after seeing the order, has rejected the writ appeal, noticing not their conduct. And granted, I think your lordship were extremely kind in granting them 4 more weeks' time to comply. And my lord, I think a stand being taken today is really contemptuous because last time's order on 9th of April, your lordship made it very clear that this has already been done. And the statement made that we want to carry out the survey itself is aggravated contempt. My lord, the 136(3), under section 136(3), they wanted to change the mutation of the property. It was nothing more. First they said grant is illegal. Grant was upheld. This honorable court said grant is legal. Then they initiate one more 136(3) proceeding. I come back again saying, please conduct the podi and duress. Every single time, my lord, they have done one or the other to ensure that this is not completed. My lord, may I kindly see page 23.
Lord, as a last chance, my lord, 4 weeks, Lord, the notices were already dispatched to final opportunity, my lord. One final opportunity, my lord. We have dispatched the notices. I will place before this court, my lord, all the notices that has been sent to their. Please, we will comply, my lord. We will comply.
This is the last order, last chance, last opportunity, last leniency. It's very lamentable because honestly, we are hesitating to say not to court. We are afraid of.
But we apologize.
With this officer. The least we are going to do is directly have issues of notice. Regards conduct, the misconduct of not, if not conduct, it's certainly misconduct not to comply with the court. That was we are going to do 2 days. And what they you say about the conduct proceedings, comply. We are making it very clear. In no circumstances, no place. With your arrests and call the police officer of the nearest police station. Let things go to bed right now.
I apologize. I apologize. Let's.
Yes, we call it the police officer.
Let's second your king. Let's at least second. Lordship may have it on second. Second.
No, come on, you comply, you go whatever the bindings, you go to your place, comply and come back. This is not the way the High Court ordered it, right? Like I said that, in every university is better. Yes, what do you want to do? Complete the facts, Mr. Counsel.
Please, I understand.
You are the officer of the court.
Please.
Do not defend such action.
But
And you are citing your officer.
we'll do it, my lord. We'll do it.
Do it tomorrow. The certainly order is full. Once contempt is concerned, I never spare anything. It is our collective responsibility that the orders of the court should be complied.
Please.
Unless it is yes. The small order or big order.
Please.
Tomorrow it comes down. We directly deputy commissioner to issue notice to the justice. Why is committed misconduct of
We'll comply.
and taking such a aggressive stand to the court. Is it super court?
We'll comply it, my lord. No, my lord. We'll comply it, my lord.
No, not for contempt. Contempt was for directly officer, deputy commissioner to take action on issuing notice. Committing misconduct and will spell out what is misconduct. Before an inquiry and punishment. Once you give a finding that there is
Lord,
misconduct, I call the room, let's
I apologize, my lord. We'll do it, my lord. We'll comply the orders of the court. Undertake, my lord. Undertake.
you are entering all such. Last time also there was some.
I apologize. Please, please.
Jesus.
Because first time you this was
Please, we'll do it.
There is a good reason, Lord. I can't say it in court. It's a very good reason. And if I really must file it. Bangalore itself. Grateful.
Counsel for petitioner, my lord. Tomorrow.
Pension plan of 2020.
They are constructing a building within 25 meters from the center of the district road. Now I have received instructions to say that the owners have not applied for permission. That doesn't survive, my lord. My lord, on the last occasion, wanted me to buy these instructions. It is stated as paragraph 5, my lord, in terms of page 3. No, my lord, they haven't asked for a sanction plan or for permission. That is what is stated by the DC revenue in paragraph 5, page 3. They can tell that after the final.
7 and 8 is not asked.
No.
My senior held up in another court, my lord, Arjun. Tomorrow. Yes. Tomorrow.
Are you aware what she said?
Yes.
Number 10.
I beg to appear for the petitioner, Lords. Lords, pursuant to your Lordship's order of 15/4/25, there is a compliance affidavit filed by the state. Now, Lords, I have two submissions on this affidavit. In para 2, my lords, the registration of an FIR is referred to. This FIR, my lords, has been registered against the deceased. Whereas, as per the POCL judgment, my lords, the FIR has to be registered in respect of the encounter. So the offences that are mentioned here, as regards assault and obstruction of a person carrying out lawful duty, etc., it's a non-starter FIR because it is against, my lord, the deceased. In fact, that FIR would need to be placed before your lordships to see how PUCL's direction is not complied. because a magisterial inquiry has to thereafter take place, Lords, under 176 of the CRPC, now 196 of the BNSS. The other thing is, my lords, the post-mortem report would kindly be summoned to be placed before your lordships, because it is the basis of the post-mortem that your lordships would then decide, my lords, what further directions are to be issued. So really there is, my lords, only partial compliance of your lordships' directions. If I may take your lordships back.
There is no need to call for the postmortem.
No, that's not required, Madam.
But about
So far as that is concerned, in fact, I had also the deceased attacked the police, my lords. So it was a case of self-defense. In fact, my lord, I suggest even if it is a case of self-defense, a complaint has to be registered, my lord. So they said they look into it and get back only on that.
But you have to file complaint. Complaint.
Yes, my lord. So
That it was an encounter.
Yes, my lord. That is the because as my learned friend was saying, my lord, if we even assuming it is a case of self-defense, that has to be mentioned in the complaint is what I'm giving.
Mr. Sondi, that will be open.
No, so that FIR has not even been registered by the state, my lords. My friend is fair in making that submission.
FIR is filed.
No, FIR is as my learned
FIR
friend
is
saying,
against the deceased.
Deceased, my lord. So we'll.
My lords, just see the direction in PUCL. Direction at para 31.2.
Your the judgment was
Mr. Sondi, this what you are saying has to be done at somebody's instance. Somebody must be complainant or not.
Yes, my lords. The one of the police officials would have to be the complainant to register the FIR. If my lord just
31.3, your lordship may see.
Before 3, my friend may, my lords, read
31.
Just kindly read 31.2 first, my lords.
Of judgment.
The judgment, my lords.
Yes, my
that was
lords.
given to your lordship. That is 2014, 10 SEC 635.
Lion.
My friend will also agree, my lords, the FIR cannot be against the deceased person. There can be no inquiry. 31.2, my lords. If pursuant to the tip-off or receipt of any intelligence as above, encounter takes place and a firearm is used by the police party, and as a result of that death occurs, an FIR to that effect shall be registered, and the same shall be forwarded to the court under 157 of the code without any delay. While forwarding the report under 157 of the code, the procedure prescribed under section 158 of the code shall be followed. Then, my lords, an independent investigation shall be conducted by the CID or a police team of another police station for the following. Please now see 31.4. A magisterial inquiry under section 176 of the code must invariably be held in all cases of death which occur in the course of police firing, and a report thereof must be sent to the judicial magistrate having jurisdiction under section 190 of the code. So therefore, my lords, this entire scope of inquiry requires an FIR as regards the encounter death. What the state, my friend does not mind, what the state has registered is an FIR, my lords, against the dead person, alleging that he obstructed the police. But the FIR has to relate to the conduct, my lords, of the police officers involved in the encounter.
No, it's like this, my lords. Insofar the FIR has been registered as to the incident, what is the FIR. The question whether the police, my learned friend says, police has to be made and accused. That is the question which will be conducted in an inquiry under, as mentioned in 31.4. So the lordship may kindly see, FIR has been registered saying under 307.
If, my lords, the FIR is under 74, 109 and 132, they pertain to, my lords, an act against a public servant. If
Therefore,
the FIR
what I'm saying is that
if my friend places the FIR before your lordships, it will be, my lords, quite clear.
This is correct, my lords. What ought to have been registered is of 307, the death which has taken place, my lords.
Yes.
The FIR ought, The FIR ought to have mentioned that, so that an inquiry as directed on 31.4 will include that provision, that's all, my lord.
So we have to see the contents of the FIR.
Yes,
We'll place that before you, we'll place it tomorrow itself, my lords. And insofar as
But Mr.
what is required is,
Now the FIR was registered here.
FIR has been registered, my lords.
When it was registered?
On the very same day, my lords. It was registered on 13th April 2025 at 23.
So the encounter, alleged encounter is post FIR.
No,
Please, no, after the encounter, my lords, there are two FIR. After the encounter, FIR has been registered, my lords. Only thing what ought to have been, I mean, I say, my lords, is the requirement of the death is not mentioned, my lords. What has been mentioned is of him counterfiring and assaulting the.
FIR was registered after this encounter.
Yes, my lords.
so my lords, after the encounter, the FIR is registered against the deceased. Whereas the inquiry that has to take place under 176.
What will be the next step in the pursuant to FIR? Inquiry?
Inquiry, my lords, as regards the cause of death of the
So in
deceased.
that,
So therefore, the FIR can never be against the deceased himself.
No.
So this is
Question is, my lords, it has to be, my lords,
My
we
friend
cannot
does not
say.
mean I'm just assisting your lordships. I'm not taking issue. It's
we can say that
But we will clean up. But with the death from that.
no, my lords, if your lordship just see 176 of the
what the court thinking allowed, without concluding is that if the investigation is to ensue after this FIR, the court can observe that in that investigation, the aspect of encounter shall also be.
That is, I bow down to your lordships, my lord. That is what
that
will
is
be
fair,
looked.
but
If the material is found, then the
Yes, my lord, that is what it has to be.
the accused officer shall be arraigned as.
Your lordship, I bow down to your lordships, my lord.
my lords,
My lord, what happens, my lord?
lords, I welcome that from your lordships. It's just that the FIR itself must then name the police officers.
No.
concerned.
The question is, my lord, if they have not done anything, how can you name and
Just
say
one
that he has
moment.
committed an offense? The lordships can't direct and
Lords,
accuse.
my friend is not.
We will not able to direct how to file FIR.
Only after.
We can suggest how investigation to begin.
Yes, my lord. We are bound, my lord. The question is to.
So, my lords, the investigation, then I welcome that.
So
During the
Mr. Sondhi, court can take care of that the investigation will have the dimension of alleged encounter.
And absolutely, my lord.
Yes, and that then the my lords, the consequent inquiry in terms of para 31.4, the magisterial
It is
inquiry
taken
would
care
be
of.
in that
It is
regard.
taken-
Will be in
I
that
have no
regard.
objection to that.
Very, very well, my lords. As long as the investigation and the consequential magisterial inquiry under 31.4 looks at the element of the encounter being genuine or fake, I'm in your lordship's hands. But the state could not have confined the FIR, my lords, only to these sections.
I bow down,
The
my lord,
death-
it can be closed
death is
on
not
what
even
the lordships are saying. My lord, whether the encounter is genuine or fake will be looked into, my lord, after, based on this FIR, my lord, when they inquire into the matter by the magistrate, my lord.
Maybe your lordships would like to see the FIR, my lords. It's
We'll say that notwithstanding that you produce the FIR to me.
It's right here, my lord, but I got
Not-
only one case in
we'll
Kannada,
say-
my lord.
We say
Oh, she's got it.
notwithstanding the fact that FIR is against a dead accused,
Dead accused, please.
it will be investigated.
In-
Its all aspects, including the allegation that it was a death in an police encounter.
Police. Please, Manoj, in terms of 31.4.
Yes, after referring to this direction.
Please, Manoj, we are not hiding anything, Manoj. We'll be able to, we are bound to comply with that. And one other aspect, Manoj, kindly permit us to bury the body, Manoj. We have complied with the Supreme Court judgment as well as your Lordship's direction, Manoj. And we have retained certain parts of the body also for if required, and because we will not be able to keep it further, Manoj.
On burial, I leave it to your lordships, Manoj. The post-mortem report, Manoj, I am requesting. Ask her to get sample FIRs.
So for orders tomorrow,
Please.
tomorrow, we'll comprehensively dispose,
Please, Manoj.
including permitting you to.
Please, Manoj.
My lords, my prayer for the post-mortem report may
Manoj,
kindly
that
be.
may not arise, Manoj.
No,
Manoj.
I don't know why my friend is interrupting me. My lords. The reason I'm submitting it. In earlier direction also was, my lords, at PUCL's instance, the post-mortem report would show prima facie, my lords, whether the death was indeed in the course of, my lords, a genuine encounter or not. From the affidavit and the FIR, it appears that this accused was not handcuffed. He was shot multiple times.
Manoj, I object to all the statement, Manoj. I object serious objections to my learned friend making such wild.
I'm going by the affidavit, sir. Basis that, my lords.
The post-mortem report is the material to
We'll
be
give it,
used
place it before the inquiry, Manoj.
in
All
the
that investigation. We'll
Why
place all.
this, why record of this?
It's only to.
My lords, the other prayer before your lordships is to, my lords, have the inquiry committed, my lords, either by a retired judge of this honorable court or even to be, my lords, passed on to an independent investigating agency. At this stage, I'm not, my lords, on that. The post-mortem will show. The post-mortem will show prima facie, my lords, whether your lordships would consider those prayers. So at this stage, I'm only saying.
Matter has been referred to.
The state should not be shy to.
Matter has been referred to CID, Manoj, independent investigating agency already, Manoj.
Who is investigating?
CID, Manoj. We are not given to the local police. Independent investigating agency, Manoj, has been already been given immediately, much prior to approaching this court. And they are one of the best officers, man, who are doing all the investigations. We have not given it to the local police.
There is no circumstances to suggest that to shift the inquiry.
No circumstances.
Circumstances can only be gathered from the post-mortem.
That is future.
No, it's not a laughing matter.
Subsequently also they can seek the shifting of the inquiry.
Yes,
to some different agency. If so.
If it comes out, Manoj, at a later point, to jump the gun is too premature, Manoj. Yeah.
So it is with CID in terms of this Supreme Court.
Please, Manoj. In fact, the Supreme Court judgment also says, Manoj, we can give it to the adjoining station, Manoj. What we have given is to the CID. Where is my mark copy? It was right here. In fact, Manoj, your lordship may kindly say, Supreme Court also says an independent investigation into the incident or encounter shall be conducted by the CID or police team of another police station. Para 31.3, Manoj.
Of this judgment.
So of this judgment, Manoj, 31.3, that paragraph, page 656. An independent investigation to the incident bar encounter shall be conducted by the CID or police team of another police station under the supervision of a senior officer, at least at the level of the head of the police party engaged in the encounter. The team conducting the inquiry shall at a minimum seek all this. This is what we are doing. In fact, we could have gone for a police station, Malod. We have gone for a CID itself, Malod, even much prior to coming to this honorable court. And
May
the
I
investigation is
respond to my friend's submission that it has been given to CID, there is no doubt. But what has been given to CID is an FIR against the deceased person, as I respectfully submitted. Had the FIR been a bona fide FIR with regard to the encounter, then, my lords, the state's conduct would have been fair. Here, what has been done is the FIR is drafted in such a way that it's a non-starter FIR, and that has been given to the CID. So if your lordships are pleased, the FIR may be looked at, and then, my lords, your lordships may pass the appropriate orders in the case.
Malod, in the FIR itself, Malod, our scope is to conduct into the incident which has taken place, Malod, or the encounter which has taken place. So the question of in the investigation, the investigation is only on that issue, Malod.
So would you able to translate the?
We'll do it by tomorrow, first thing in the.
By tomorrow?
First thing in the morning, or if possible, we'll try and give it.
Tomorrow, then.
And one other thing, your lordship.
You can proceed for burial. There is no.
Please.
There is no restraint order.
Yes. There's no restraint order, but I thought before doing, inform your lordships, because it should not be overreaching the court when the matter is being heard. Malod. One other thing, Malod, if your lordship may kindly see, I agree to my learned friend, FIR is not.
In this public interest petition, detailed order was passed on 15/4/25, pursuant to which the state has filed where is your state through Sovereign Police, HNB Division, CID, CAR, LTO, and Carlton House, Palace Road, Bengaluru has filed affidavit in which inter-alia effect of filing of FIR.
You can give it. This one. Who gave the complaint? Wait, you have to give both.
As well as carrying out of a postmortem.
Please, Pasco.
Are mentioned. Copy of the FIR was sought to be placed on record. Post of learned advocate general, additional government advocates, Srimati Nilofer Akbar, stated that since the FIR is in vernacular, the English translation will be filed by tomorrow.
What we'll try and do, Manoj, if possible, so that it assists your lordship, by the end of the day, if you can give it to it, Manoj, we'll try and send it across.
Learned, get Mr. Sondi. Aditya Sondi. Submitted that the FIR wanting in its proper content, in as much as it has to include the police officers, as it has to show the police officers as accused persons, as involved in the alleged encounter. He further submitted that the copy of that the court may direct the disponents to produce on record the copy of the post-mortem report. Paragraph. As far as the last request is concerned, the court does not see any justification, inasmuch as the post-mortem report will be needed only to the investigating agency.
Correct.
At this stage, learned Advocate General requested that the body of the laborer died in the incident may be permitted to be buried, since the post-mortem of the body has already been undertaken and the parts as required
Yes,
has been preserved
please,
to aid the investigation.
please.
Full stop. It is to be stated that there is no restraint from this court, at least now,
As a-
for burying the body.
Yeah.
The authorities are permitted to, what,
To bury the body.
to bury the body. Full stop.
One other aspect.
And
Malad,
second for orders.
Please, independent of that, Malad, if I'll give the translation, the CAD in the course of investigation, there's something investigate, they can always,
Mr. Sondi also submitted that the investigation needs to be done by independent body. Full stop. Then after recording this, permitting you to bury the body, we are keeping this for orders on second.
please,
By the time you file the
translated copy.
translation.
Your Worship.
So supply the translation
We'll do that. Malad. First thing in the morning, we'll do it.
and give the copy to others.
I'll give it to my learned friend also.
There is no dispute. about
I'll give it to my learned friend also.
I'm grateful to your lordship.
Second of
ये मुझे- Second,
it's Friday,
अरे, not second,
June.
tomorrow. No,
Oh, tomorrow.
day after.
They have, tomorrow is holiday.
Friday,
Malad.
Friday,
Friday.
Friday.
Your Worship, kindly excuse my presence on Friday, not just.
Only for
Please.
orders.
My friend must be taking a good vacation, my lords. I'm so grateful to your lordships. Grateful.
Tomorrow we will not be able to.
No, I understand. Malad. We'll have it. I'll give the translation first thing in the morning after serving a copy on my friend. And
We'll record your presence
please,
as argued.
please, grateful.
Lords, may we also place some illustrative FIRs that have been registered in other cases, my lords, of encounters for your lordships?
Malad, here is the case, Malad. To my learned friend also, let
a-
there not be any apprehension that once, as my learned friend, there is a certain lacking, Malad. But the question is, once it is handed over to the
But I
CA,
am explained by my brother that the FIR refers to encounter.
it refers to encounter. The question, no, what my learned friend wants is an FIR. So there, what? Your Worship,
Both FIR you give and
both the FIR, in fact, that is what both the FIRs were giving. And para 3, Manoj, it is enumerated, but only question what my learned friend is trying to say, police should be making accused, that cannot. The question is during the investigation, if they are involved, then it will be registered. That is what your Lordship said with regard 31.4. Inquiry will be done. Then after that, if it's not satisfied, then there'll be a further direction if required to be done.
My lords, for that a murder charge must, or a homicidal charge must be mentioned in the FIR. I'll
at least I am understanding the criminal matters without conducting it. Never conduct. Yes. So
please, my lords, your lordships will see the FIR. I'm grateful. I'm
yes,
grateful.
we will see both FIR. Mr.
Please, please, please. I'm grateful.
Before passing the final.
Seal number 11. Mr. Abhishek.
This, Lord, question was whether old pension scheme, new pension scheme will apply. On last occasion, my lord, when it matter came up, my lord, I said, my lord, we will ascertain. There are 32 lakhs, my lord, which is, my lord, under the new pension scheme, my lord, which is available. We will deposit it in this honorable court, subject to, my lord, without any prejudice. And your lordship, my lord, probably, my lord, will decide that matter, my lord, on merits.
what happens, my lord, I have made loans because of no payment has been made to
No,
me
that's
in
what
any
I'm saying.
form.
I'll deposit.
Let some amount be, my lord, released to me either as a commutation or as part of the NPS according to them, which, my lord, my on instructions I'm stating, under NPS, my lord, I was to get 16,000 rupees pension and 26.
So you deposit the amount.
I'll deposit this
But
amount, my lord, in
a
this.
part of that may be allowed. Otherwise, my lord, I
I will
cannot.
not even say anything more.
No, undisputed amount if it is given to them.
Yes, because, my lord, even under NPS, I'm so sorry, my lord, I'm interjecting.
Only thing
20,
is, sorry, it is, my lord, his contribution he has taken. It's the employer's contribution, my lord, is 32. That is under the new pension scheme. So, my lord, that new pension scheme it applies, my lord, we will, only thing is whether, my lord, new pension scheme will apply, old pension scheme will apply, your lordships will decide.
Lord,
I'll deposit it here, my learned friend can probably withdraw.
both. Yes.
I'll
Let him
deposit it in
deposit,
this
I
honorable
may
court,
be
he can
given
withdraw,
liberty.
my lord, thereafter.
Yes, because that, my lord, my respectful submission is, my lord, I am on instructions that 60.
Will permit you to withdraw the employee's contribution.
Employer's contribution, employees is already withdrawn.
No, but I have not, no.
Yes, my lord.
Illa,
What
because
has, I'll tell you, lordships, what has happened is, there is the employee's contribution, there's the employer's contribution. Employee's contribution, my lord, of 28,000, my lord, 28 lakhs, he has already withdrawn. Huh? Alva?
Illa, no, that's not correct, my lord.
2,000.
Illa. May I, my lord, clarify before my
8
lord?
lakh, my lord, I stand corrected. I stand corrected, my lord. I'm sorry.
8 lakhs.
I stand corrected. It is 8 lakhs, my lord, he has withdrawn. There is the employer's contribution, my lord, which is available, which we will not deposit in this honorable court, 32 lakhs.
Yes, it is not withdrawn, my lord. I was told that you are not entitled for NPS. You are entitled for OPS. So I was given back my contribution.
For claiming under new scheme now.
Yes, under the, yes, I was brought under the OPS. I was initially under the NPS and my contribution was given back.
That's all right. I know that.
I am not. No. Now, my lord, I am neither, sorry.
You're only one employee.
Sorry, my lord.
You're only one petitioner.
Yes.
There
I'm
are
the only
a couple of others I am told, they are not filed, they have not filed. And state also, my lord, there is a lot of ramification in the state, therefore state has also filed a petition.
State is also on record, my lords.
My lord, I am the only case of my kind because they said, my lord, you are not under NPS. You come under OPS and they relegated my amount back. May I make one submission, my lord, if lordships permit? One, my lord, under the NPS, I will be entitled to 16,000 rupees pension plus 26 lakh rupees as one-time payment. 16,000 rupees and 26 lakhs. Now under the OPS, my lord, I am entitled to a pension now around, my lord, 18,000 rupees, which is, my lord, a paltry sum. There's absolutely no, my lord, meaning in getting, and I will not get the commutation under the NPS. So, my lord, let them deposit that amount. I may be allowed to withdraw that under protest subject to outcome of this writ petition. I will argue, my lord, and make out a case that I am entitled to OPS, old pension scheme. That's what I'm saying.
I am told retirement gratuity of 18.50 lakhs have been paid. Leave encashment of 25 lakhs 0.28 has been paid.
Gratuity.
Gratuity of 18.50 lakhs and
Not as
leave
part of-
encashment of 25.28 lakhs have been paid already.
That is not part of the pension.
That's all right. I'm not saying anything. I'm
Saying
not.
as
for a
pension, I
minute-
have not got a penny.
I
I'm
understand. I understand. I understand.
I'm
my lord.
neither under
After all-
NPS nor under OPS. Lord. I'm in a very precarious, unenviable situation.
The challenge in this writ appeal is is by the university to the appellant university to the judgment in order dated 18th June 2024. Whereby learned single judge allowed the writ petition set aside endorsement dated 22/1/24, issued by the university. The dispute is whether the petitioner is entitled to receive the pension under the new scheme or is to be governed under the old scheme. Paragraph. The appeal heard learned senior advocate Mr. Uday Valla, assisted by learned so-and-so, and learned advocate Mr.
Sridhar Prabhu.
Sridhar Prabhu, with learned advocate Mr.
Aishwarya.
So-and-so. The appeal, in the facts of the case, the appeal deserves to be admitted. It is admitted to be listed next on 21st July. At this stage, and advocate will respondent to original petition, respective of the aspect whether the original petitioner, who is a professor,
Sorry, Miller.
you are a
Professor, yes.
who is a
I
professor,
retired as a
entitled
professor.
to be paid under the new pension scheme or as per the old provisions of the scheme, comma, the amount as may be admissible under the old scheme
Sorry,
may be paid
Under the new scheme, Malad.
under the new scheme,
no, that is there. No,
That's right.
maybe
Without prejudice.
under the new scheme as per the university may be directed to be paid.
under protest. Under protest, because I am not saying I am under OPS.
So it is employer's contribution, which will be the amount deposited towards employer's contribution. Countering this submission, learned senior advocate for the appellate submitted that the petitioner has already paid gratuity amount of 18.5 lakhs and leave encashment to the tune of 25 lakhs.
25.28.
25 lakhs. He therefore submitted that sufficient amount is paid to the petitioner, which are the retirement dues barring the pension. He further submitted that what amount is deposited?
32 lakhs, Malad, we will deposit in this honorable
They
court.
will deposit.
15 within 15 days.
That considering this, that rupees 32 lakhs
32 lakhs we will deposit in this.
Will be
32 lakhs, Malad.
that the appellant shall be depositing 32 lakhs.
Please.
Appellant university shall be depositing rupees 32 lakhs
Which is the employer's contribution. I'm sorry, I'm interjecting.
with the registry of this court, which is the amount of employer's contribution under
NPS, new pension scheme.
the new pension scheme.
Within 15 days is what they're saying.
In facts of the case, without in any way adjudicating the controversy or going into the merits of the case of the either side, as an interim measure, subject to outcome of the appeal, an amount of rupees 7 lakhs.
No, my lord.
Shall
I'm
be
really
permitted
under
to be-
distress, my lord. They are ready. I would have
shall
got
be
that
permitted
amount.
to be withdrawn by the respondent petitioner. The rest of the amount of this 25 lakhs shall be invested by the registry in a fixed deposit with a national cumulative fixed deposit.
Can I request for 50%? my lord, other-
Fixed deposit in a nationalized bank initially for a period of 3 months and renewable subject to further orders of the court. Full stop. The interest which may accrue every 3 months shall be paid to the respondent petition.
Please. Lord, my son is studying abroad, my lord. Can I request your lordships to at least make it 50% because they are anyway, my lord, I am under neither this nor that. I'm not getting any amount, my lord.
My lords, there's a connected state appeal. It may also be admitted, my lords. Connected state appeal, my lords.
Lords may at least make it 20 lakhs, my lord, because NPS, if I had entirely got the NPS and not OPS at all, my lord, I would have got 20 lakhs. That's what I'm pleading.
The appeal is not heard within reasonable time. You can file IA for further withdrawal. Specifying the ground.
Please. And within a time-bound manner, my lord, this deposit.
15 days we will deposit.
Within 15 days.
Please.
Deposit within 15.
Please.
32 lakhs.
And a date may be assigned, my lord, if you're
It's fixed
Already
on
given. Yes, sir. My lords have already indicated.
21st July.
Correct. Please.
Connected state appeal may be admitted, my lords.
Very
Connected state appeal is also connected, my lords.
Writ appeal number 334 is also admitted, which is arising out to the same judgment.
Very much, my lords.
After hearing learned so and so, the appeal is admitted. This appeal is admitted.
Here.
As arising out the same judgment to be listed with writ appeal number 174120.
ಏನ್ ಮಾಡ್ಲಿಕ್ಕೆ ಆಗೋದಿಲ್ಲ.
List one, serial number 130.
So contempt will not survive.
Very much, it may be disposed of, my lords.
In view of the contempt will not survive. Contempt will not survive.
No, that be there, my lord, because if I succeed ultimately, my lord.
Then
They are depositing the amount.
Sorry, my lord.
They are depositing the amount.
No, not the entire, no, my lord. I am under the OPS, under the old pension scheme. This is only new
That's
pension
in
scheme.
percent
That
of-
is what I am submitting repeatedly, my lord. This is not what I am entitled to, my lord. Because I am ultimately, lordship may say, my lord, without prejudice to my rights and,
Keeping pending.
yes, lordship may say, my lord, without prejudice to my rights and contentions. Otherwise, my lord, it will be taken that I only suggested that.
Without prejudice.
Yes,
We'll add
without
that.
prejudice to this, to the outcome of the appeal.
Deposit will be without prejudice.
Yes,
Also withdrawal.
yes.
We were thinking to dispose of the contempt, but then the council says that let
I am
it be.
saying, my lord, I am under OPS, subject to what, ultimately, if I succeed, my lord, then I will be weaponless.
I mean, your lordship stands, my lord. I never.
Let 7 lakhs, my lord, I am really under distress. I am not saying this, my lord, I will not repeat again.
Keeping pending, there is a minor thing. Let it be pending.
No, I am under distress, my lord, financial distress. That's what my submission was. I am not
That-
taking any amount at all.
That will see subsequent. Right now, only 7 lakhs.
10 lakhs at least your lordships may make it, my lord. A round figure, otherwise, my lord,
This is what 7 is best auspicious figure. 7 is auspicious.
at least 10 lakhs, my lord, because I am under financial distress, my lord. Otherwise, I won't press it beyond the. I leave it at that.
Really.
List one, serial number 130, Mr. Naveen GS.
Which one? List 1. Yes.
Let's say we permitted to place on record the judgments.
Copy. Synopsis. Lord, we wanted to place one judgment, my lord, towards the fag end of the argument on previous occasion, my lord. One citation, my lord, of the Honorable Supreme Court on the proposition of law insofar as the alternative remedy under section 72C, my lord, of the Cooperative Societies Act in the matters relating to election petitions, my lord. That is the only submission, my lord. We would like to place that judgment stating we have already passed on last occasion, my lord. It's in the case of Umesh Shivappa Ambi and others. Paragraph 4 would be relevant, my lord, where the Honorable Court has said, Supreme Court has said, if your lordship permit, I will read it. It's a small paragraph, my lord. It says the learned single judge, it is now settled that once an election is over, the aggrieved candidate will have to pursue his remedy in accordance with the provisions of law, and this court not ordinarily interfere with the election under Article 226 of the Constitution. The court will not ordinarily interfere where there is an appropriate or equally efficacious remedy available, particularly in relation to election disputes. In the present case, under section 72C of the Karnataka Cooperative Societies Act 1959, any dispute arising in connection with the election of a president, vice president, chairman, vice chairman, secretary, treasurer, or member of a committee of the society has to be referred to the registrar by raising a dispute before him. The registrar is required to decide this in accordance with law. My lord, it is, in this case, my lord, it is for the election of the treasurer, my lord, is covered by this judgment. That is my responsibility.
Lords, my only submission is, my lords, in my memo, my lords, page 22, my lords, the Honorable Apex Court has clearly stated that it is well settled that where a statute provides for election to an office or an authority or institution, and if it further provides a machinery or forum for determination of dispute arising out of election, the aggrieved person should pursue his remedy before the forum provided by the statute. While considering an election dispute, it must be kept in mind that the right to vote, contest, or dispute election is neither a fundamental nor a common law right. Instead, it is a statutory right regulated by the statutory provisions. As such, my lords, they have to pursue the remedy under section 70, subsection 2C of the Karnataka Cooperative Societies Act, my lords. Further, my lords, that sought for a prayer to set aside the election of the appellant. That prayer has not been awarded to the respondent number 1, my lords. As such, fresh elections could not have been ordered without the earlier election has been set aside, my lords. Okay.
My lord, in so far as Sir. With your lordship. My lord.
B.N. Mahesh Chandra, my lord.
For respondent number 4 and 5.
On submission, my lord.
4 and 5, returning officer.
Respondent number 1, caveat to respondent number 1. My lord, I may be permitted to make one submission in respect of this citation which is produced. My lord, it says the court will not ordinarily interfere. It does not say that it will never interfere or there is no scope for interference. And in so far as the another judgment pointed out, my lord, even after coming into, after this judgment has been delivered, that Godrej Sarali Limited, which was referred to on the last occasion, which was produced by me, in that, after the passing of this judgment, that judgment was passed wherein it is stated that when it comes to the interpretation, when the question is in respect of interpretation of a rule or a statute, then the High Court has the jurisdiction to entertain the matter under 226, my lord, because that cannot be done by an authority as such. And here the very particular aspect which we have pointed out that is, if that was the case that no person should propose two persons for the same post, then the situation is very worse, because my lord, there the same proposer has proposed both of them for the same post, my lord. If that is the ground, then it ought to have been rejected, my lord. But a different principle has been adopted while rejecting my nomination, my lord. Because here, the one who has proposed or seconded me has never proposed or seconded anybody else for the same post, my lord. That is my submission, my lord. So insofar as Rule 14 AG of the Karnataka Cooperative Societies Act is concerned, it has been wrongly interpreted while rejecting my nomination, my lord.
Great, sir.